Move a review of the 272-day delay. One line explanation in the application for condemnation.
The service of notice is not complete. Number 8, no? Huh?
The only problem is if it's passed over and once the lordship take up the bail matter.
Service of notice is not complete. On whom it is not complete? Respondent 1.1, 1.2, 1.3. Office report indicates service of notice is not complete on respondent numbers 1.1, 1.2, 1.3, 5, 8 to 13, 17.
Well, we are there for some of those.
18, 25, and 29. Petitioner to take steps in respect of unserved respondents. List in 3rd week of February.
In
3rd week of February. Item 9.
My lord, in item 9, it's an appeal for enhancement of sentence, my lord. Service has been completed, but yet the respondent has not appeared, my lord.
Service of notice. Here the state.
Please, my lord.
Serve it by Dasti.
Through SHO, my lord. Very well.
Petitioner is this the office report dated 31/10/2024 would disclose service of notice is complete as per the track report of the postal department. Which stop para the petitioner state is seeking for enhancement of the punishment. Hence, we direct the petitioner to take out notice to the respondent through Dasti, namely to effect the service through the jurisdictional SHO and file an acknowledgement. First week of March.
Very well.
Date then. Item 10.
Well, this matter is coming up after notice.
Your opinion?
Yes, no, Your Worship, granted litigation expenses.
25,000.
Yes, no. So it's my pro bono. You cannot feel bad that I'm appearing.
You pro bono, is it?
It's for my Your Worship, granted litigation expenses. I just want to make it clear.
All right.
Yeah, please, my lord. My lord, I've just prepared a one-page list of date for my lord's convenience, man.
Please take it.
May I please? My lord, in 1994, respondent joined the bank as armed guard. On 30th of April 98, after 3.5 years of service, a customer of the bank alleged that respondent has misappropriated his money. Respondent admitted in writing to the customer of bank that he has deceived him by taking money for depositing in a recurring account of children of customer, however kept it with himself. He assured him that he would return the amount on 6/5/98, however never returned the same. Respondent advised the customer that he was unable to pay and shall pay the amount tomorrow. These are all letters, my lord, which are marked as exhibits. Then 9/6/98, the said customer made a written complaint to the bank stating that for 17 months, respondent took money for deposit, however, has not deposited the payment in his children's account. Respondent was issued a charge sheet and subsequently inquiry officer was appointed.
Yes.
During course of inquiry, respondent submitted a letter to the DA admitting of misappropriation of customers' money. So this letter was given before the inquiry officer itself. DA ordered fresh inquiry to be held. Respondent submitted his defense response. IO report submitted holding charges of misappropriation and was not proved as customer of bank was not examined. DA disagreed with IO and awarded punishment of discharge from service. In a writ filed by a respondent in the year 2001 challenging his discharge, the learned single judge of the High Court dismissed the same. In a writ appeal filed by respondent, the DB of the High Court remitted the matter back to the disciplinary authority to commence proceedings from the stage of issuance of fresh show cause notice to the appellant, indicating his tentative disagreement with the finding ordered by the IO. On 29/6/2012, the disciplinary authority issued a tentative note on dissent with findings of the IAO. Now 10/2/14, my lord, once again in response, the respondent admitted having issued the letter of 25/10/99 wherein he admitted that I have done this, wherein he admitted his guilt with a hope to conclude the inquiry. Now this was, my lord, after the High Court passed the order. 25/3/2014, by its order, the disciplinary authority passed a final order imposing punishment of discharge from service and superannuation benefit as it would be due otherwise at that stage and without disqualification for future employment. Award, my lord, was passed on 4/10/16 by the CJIT upholding the order of punishment holding charge as proved. 14/10/19, in a writ filed by the respondent, the learned single judge also upheld the award and punishment imposed. In pure order, my lord, in the writ appeal filed by the respondent, the Honorable Division Bench of the High Court.
Ground on which the writ appeal was allowed?
My lord, the writ appeal was allowed on the ground, my lord, that on 23/12/2011. Allowed it on the ground that when the matter was remitted back to the disciplinary authority, after that no fresh evidence was led to prove the charges. Well, fact of the matter was, my lord, in response to that tentative note of dissent also, once again the respondent admitted that he has issued this letter and admitted his guilt also. My lord, may kindly come, my lord, I have made a just short submission note, my lord. All throughout in the inquiry as well as before the DA.
No, what is the ground on which the appellate court?
That's what I'm.
finding of the
Yes, my lord, may kindly come to. I'm coming to that.
Huh?
Page 5, my lord. Paragraph 6.5, my lord. When the order of remand was passed, this is what they are quoting from that, my lord. The above was challenged before this court. The said petition was dismissed. The learned single judge was challenged. The appeal was allowed principally on the ground that decision of DA was in gross violation of principles of natural justice and also holding on merit what disciplinary authority could not do. Those paragraphs are as under. Now coming to the facts of the case, out of 6 charges, inquiry officer found that only 1 charge was proved. Such regarding non-deposit of amount taken from depositor was found to be not proved in view of failure on the part of complainant to appear before the inquiry officer. Except the complaint, there was no other evidence before the inquiry officer. Even the branch manager who received the said complaint was not examined. Therefore, the inquiry officer was fully justified in his conclusion that the documents were not proved. Mere production of document alone is not sufficient. It should be proved in the manner known to law. The disciplinary authority resorted to a shortcut method by saying that the appellant has given his confession and as such documents are proved. While giving such a reason, the disciplinary authority conveniently omitted to note that the earlier report was not taken note of and a fresh inquiry was ordered only because of recording a finding on the basis of confession. And the fact remains that even during the second inquiry, other than the complaint given by a Jaipal, there was no other legal evidence before the inquiry officer with respect to the principal charge. Then my lord, 28 is the course adopted by the disciplinary authority was in violation of natural justice, and it was also against the law laid down in PNB and subsequent decision in Yoginath. That was that my lord, DA while disagreeing has to give a notice, and then this punishment can be imposed. Para 32 my lord. Therefore, we set aside the order. The matter is remitted to the disciplinary authority for fresh consideration. It is open to the disciplinary authority to commence the proceeding from the stage of issuance of fresh show cause notice to the appellant. Indicate,
What was the delinquent employee? What was his designation?
my lord, he was an armed guard.
Security guard outside the.
He was an armed guard. My lord.
What is his role as a senior bank official?
No, he's not a senior bank. I'm not saying he's a senior bank. I'm nowhere said that. My lord, he's an
Charge number 2.
Please, my lord.
What is the charge number 2?
My lord, may kindly have a look at.
Where is the charge?
My lord, the charges your lordship would find page 46. That charge was, my lord, he resorted to outside borrowings without approval of the appropriate authority. You resorted to borrow money and place yourself in under pecuniary obligation to the foreign person having dealing with the bank. So, and these are various customers of the bank.
Where is the statement of facts supporting the charge?
My lord, this is what was given as a charge. Only this was what the charge.
Charge along with the statement of imputation.
My lord, this is what I find, my lord, from the record that this is the charge. This is the charge. Please, my lord.
Without imputation, without documents you rely upon, without the list of witnesses.
No, my lord. My lord, this is only a charge sheet. I don't think, my lord, we have annexed anything else apart from that.
It can't be. Which bank? State Bank of India.
Please, my lord.
You would not have, definitely would have given the statement of imputation.
That's right, my lord. You must have given that. Your lordship, kindly give me a minute. My lord, that is not here in the record, my lord. But this is what, my lord, these two charges were based on which it was issued. My lord, may kindly also have a look at this. My lord, this conduct was not only for 1 or 2 times that he misappropriated the amount. It's happened for more than 2 years or so. The amount which the customer gave to him, thinking that he must be knowing the armed guard.
What sort of customer is who will give it to a guard at the entrance of the bank
Please,
to open the account?
My lord, these are small branches, my lord.
All right, small branches.
And this is an incident, my lord, out of 1996, 97. Those are the days.
Recent.
Please, my lord. But this is what, and my lord, the gentleman, all this happened only when he only worked for 6 years, 6.5 years in the bank, when the charge sheet was issued. And my lord, here is the admission on his part.
Inquiry officer held the charges not proved.
My lord, yes. On the ground, my lord, in fact, that the customer, etc., was not examined.
Naturally. How do you prove that?
My lord, there is a judgment of your lordship that says that customer of the bank is not required to be examined because normally, my lord, in these kind of cases,
What is your charge?
a bank.
A gave the money to B.
Yes.
For being deposited in the bank.
In his account.
You don't examine A.
Please.
Automatically it falls.
My lord, it is not, my lord, your lordship judgment is there, my lord, which categorically said that in case of a bank employee, my lord, customer of the bank, normally what happens that a bank customer is not entitled to land up in this kind of situation.
You are right. If it is a clerk inside the bank, cashier inside the bank, or an officer inside the bank, or manager inside the bank, but not a security guard. Nowadays, security guard are outsourced.
My lord, security guards, we have found cases where in rural areas, people cannot fill up the forms. They go to him and ask him to fill up. And these kind of things happen, my lord, may kindly consider it from that perspective. And this is not a case, my lord.
These are the days where now, even a street vendor will send the money by Google Pay.
My lord, this is 96, my lord, 96, 97 incident. And my lord, may kindly also keep in mind, my lord, he admitted this charges in all the proceedings. And my lord, the resultant factor now is, my lord, that this kind of an employee, my lord, who has done all this now will have to be paid 65 lakh rupees.
Huh?
This employee who has done this kind of a thing, my lord, in view of the order passed by the Honorable High Court, my lord, he will have to be paid 65 lakh rupees towards back wages alone. He worked only for 6.5 years in the bank. And this is the kind of misappropriation he does. He admits it.
He has attained the age of superannuation.
Yes, he has.
Is he entitled for pensionary
He
benefit?
will get pension if in case all this period is counted. Because he only worked for 6.5 years. But now if everything is to be counted, my lord,
That we'll
and
examine.
65 lakh
We'll
rupees.
examine that aspect.
My lord would not consider, my lord, that this is case of an admission, my lord. My lord, if we don't take a
You are mighty bank.
mighty bank, my lord, but your lordship may appreciate a customer of the bank. He has been cheated. My lord, if we don't take action, then also, my lord, we are saying that we are being put to that you are the bank. How can you tolerate this kind of a conduct? Now the customer, if this kind of thing,
Why did you keep him out?
keep him.
Why did you keep him out? You were always outside. You should have continued him there.
But my lord,
Elsewhere.
that is, my lord, we cannot, my lord, prevent him that you can't enter the bank or
Who
do.
was the inquiry officer?
Who was the inquiry officer? And he was also an employee of the bank only, my lord, senior officer of the bank.
So he has, naturally, he has given a report saying that charges are not proved.
But my lord, if he admits it, I am going to show you from the documents which are there on the record. Not one, 3 times he had admitted that he has misappropriated. My lord, why should this conduct be tolerated of a bank employee, my lord?
The 251089.
18.
2510, which is that?
My lord, that is the, he admitted it on 25/10/99. Then he also admitted it again on 10/2/2012.
PW6.
Yes, sir.
The respondent submitted a letter. Well, Lord, that is the prosecution and
Because,
I think
nobody examined on the part of the
the
bank.
documents, my lord, because that was admitted by him. Which was admitted by him, page 48. With reference to your letter, inquiry officer letter, I submit the following lines for your kind and sympathetic consideration. This is what he gave to the inquiry officer and also to the DA, my lord, during the course of inquiry. My family consists of so I have to incur huge expenses in order to meet out my parents' medical expense on an urgent basis. I utilized the amount tendered by Mr. Jaipal for the credit of the children or recurring deposit account with the hope to remit the same within a short period by selling the land owned by my father. And then last paragraph, my lord, I regret from my action which was done to meet out the huge expenses on account of my parents' medical expenses. Then, my lord, again, on page 90, your lordship would find 90.
In your synopsis, you have referred to page number
48 is,
48.
that's the one, my lord. What I just now read out. And this is during the course of inquiry, my lord. And lots of judgments are there that one stages a case wherein the person required to make. Page 49, my lord, in the middle I was reading, my lord.
Yes, Mr. Counsel, whether you are ready to give up some part of the packages.
Good, sir. You wash your hands because there is nobody examined. And this, Hiroshima Candice, the letter itself, Hiroshima Candice, the nature of the letter, it was extracted from Candice page 42, the way it has been written. Just for, I have received 2 RD amount. This is supposed to have written the person.
Yes.
From whom I have taken the money. And see the language, my lord. I have received 2 RT account payable so and so in respect of say Rajkumari, daughter of Jaipal, so and so, Balaji, son of Jaipal, so and so, every month from November, so and so. From him, addressed to whom? Addressed to the very same person, Jaipal. But since the bank dictated this letter, look at the nature of the letter, my lords.
Obviously, no.
Yeah, please, my lords. I can see through the things. I can see.
You would have said, all right, we'll take a lenient view.
Yes, my lords.
Without some this
Even then, my lords, the gross
increments or without your pay or without your promotion.
yes, my lords.
If you agree, if you admit, what is this educational qualification? You would have been 10th pass or 8th pass.
My lords. And even the gross Hiroshima Candice page 37, which says that an employee found
You cannot get a bounty of your inaction.
yes.
So tell us,
In this case, my lords, I am purely in the hands of my lords, my lords. The poor
you're
person.
a pro bono, no?
I'm pro bono.
The other side he is not coming. Has he met you?
No, I know my lords. It came through my friend lawyer.
With the sense? So she is in contact, the advocate of record is in contact.
My lords, with the party, not with others. With the respondent, my lord.
He is in touch with you. Find out
We will take instructions.
Yes.
some 20 or 25% back wages, that's all. But he will be entitled for pensionary benefit
Yes. I'll enter.
if he is otherwise eligible.
Please.
The exchequer's money cannot be made to pay for his wrongful action.
And Lord, can you pass it over, my lords? So they can speak to me.
Find out, pass out.
Keep it.
To that extent, we'll modify the judgment, that's all.
It is a lot. But this kind of conduct, my lord, for the bank employees intolerable, my lord. My lord, this sends a wrong signal, my lord. That's the only way you're concerned about.
No, so Judgment 20, pass it over, minus 24% backward and so on.
So you'll have to file an affidavit.
Or instead, my lord, can I only make a request? Some lump sum payment can be made to him instead of all this, my lord.
Sorry?
Instead of this, my lord, some lump sum payment can be
No.
given to him, my lord.
No.
Because, my lord, please, Abhishek, 6.5 years only is work. Please consider that. I'm just humbly submitting. It's a bank.
According to you,
Public-
65 lakhs.
65 is the
Then
amount.
are you currently willing to pay 50 lakhs?
But I'm completely, my lord, at the end of the day, we are dealing with public money, my lord. I'm in the lordships, and as much as I am concerned, you are a lordship.
Under the umbrella of saying that we are guarding the public money,
Please.
you cannot squeeze some employee.
But this is not a matter of squeezing, my lord.
What else? Sir?
Misappropriation, my lord.
When IWA has clearly held against you,
But when there are admission, my lord, confessions, my lord, of your lordship, kindly,
Son, your manager.
not once, but at least 3 times.
under what circumstances that admission came into existence, you know.
No, please, my lord, he is himself writing letters to customers of the bank, saying that, yes, I'm sorry, I misappropriated. Then he comes to inquiry officer, writes that.
All right.
Then again, matter is remanded back, again he admits it. I would just request, my lord, and leave it to your
We
lordship.
will be able to reduce that back wages. Restrict it. Only to that extent we'll be able to bail you out.
Such case, my lord, affidavit filed.
If this act had been done by an official inside the bank, we would not have.
My lord, he's an employee of the bank. He's an employee of the bank.
Literally,
All
And
right.
these are small Google, my lord, branches. That's what I want.
Where was this branch?
My lord, somewhere inside Colombo to, my lord, somewhere.
in Salem.
District of Colombo.
It's a big town in Tamil Nadu.
And 96, 97, my lord, incident.
Still it was big town.
Parkour.
Veterinaire.
It is Shri Ganga Palyam.
Then I can but
This was, my lord, a Gajal Naik Kapatti branch, my lord, page 2 of his counter he has mentioned.
the affidavit that I'm agreeable to this is the affidavit. I should file.
File an affidavit.
Yes.
Find out first whether he is agreeable. We'll record it
Yes.
to enable you to file your affidavit.
We'll file it in
Only for consideration, we'll
Yes,
see.
ma'am. Absolutely. So Rashmi, can we post it on Friday because before that I'll complete you file your affidavit.
All right, next Tuesday.
Next. Take your rest. Be high on board. Maybe high on board.
It will be there, don't worry.
Take
May I mention it all?
it.
Yes. Item B. Sibal has come. So Kapil Sibal has come?
Because he's
So there's a mail matter we had.
That's all right.
All right, let him come, we'll see, continue. Item 11.
May please, Your Lordship. Lord, may I just hand over a list of dates, please?
Yes.
This is a case where the High Court has interfered, my lord, with the concurrent findings of the trial court and the appellate court. Court master, please.
If required